Hello and welcome to this Introduction to Construction Law Part 2. I'm Jennie Wild, a barrister at Keating Chambers, and this is a follow-up to my Introduction to Construction Law talk, which I gave with Emma Healis. Both that first talk and this follow-up are aimed at those who are fresh to construction law and are very much intended to be introductory. Today, I'm going to talk about dispute resolution clauses and forums. So let's get into the detail. There's so much I could say on this topic. I can't possibly fit it all into a short talk. So I've tried very hard to think about what I would have found helpful to know at an early stage. So this talk is going to focus on what is specific, common, and perhaps unusual about dispute resolution that's specific to the construction industry and construction contracts. And today I'm going to talk about adjudication, dispute adjudication or avoidance boards, emergency arbitration, and contractual mediation. Commonly, our audience is a mix of contentious and non-contentious lawyers, so I'm going to try and present the topics today in a way which might interest you all. So starting then with adjudication, I could provide a whole lecture series on adjudication, and indeed many of us do. This is just a whistle-stop introduction. So adjudication is a statutory form of dispute resolution which is specific to the construction industry. It's set out in many of the standard forms, but it's supported by legislation which applies when the contract does not comply with the Act. And it's designed to help cash flow during a construction project. The often repeated phrase is that cash flow is the lifeblood of the construction industry. And that's because we have long contracts, much longer than most commercial contracts, much longer than a sale of goods contract, with periodic payments, and all in the chain depend on the movement of money to keep that project moving. There are also lots of possible disputes, defects, delays, variations, extra expense claims. And for many years, if an employer wanted to stop payment to a contractor, they could bring fairly thin counterclaims, and it would take a long time for the disputes to work their way through the courts and could be quite costly to litigate. So there was a government review conducted by Sir Michael Latham, which led to the Latham report, from which we find Part 2 of the Housing Grants, Construction and Regeneration Act 96, which was amended in 2009. And it contains certain rights and obligations in relation to adjudication and payment, with what's known as the scheme as a fallback position if the construction contract fails to include the adjudication provisions or the payment provisions of the Act. So it was designed for disputes about payment, and it was designed to be quick and cost effective. Some might say it has evolved into something else, but I think that's a talk for another day. In summary, then, adjudication, the Act provides a right in Section 108 to refer a dispute arising under the contract for adjudication under a procedure complying with the section. That statutory right applies to construction contracts, which are defined in Section 104 of the Act, but have regard to the exceptions in Section 105, and in particular Section 106. It doesn't apply to residential occupiers. You need a dispute to kick off an adjudication. I've set out some guidance on the slide as to what you need for a dispute to crystallise. It has no special meaning. The claim needs to be notified to the other side in some way, and it needs to be clear that the claim is not admitted, but that could be by express rejection or a period of silence, so long as the claim is set out in a way that the other party could sensibly respond if they wanted to. It's intended to be quite speedy. The Act provides for a timetable whereby the adjudicator is appointed and the dispute is referred within 7 days of a notice, and you receive your decision within 28 days of the referral notice, subject to a number of extensions that can be provided for, leading to a total of 42 days in most instances. Adjudication is said to have temporary finality. Usually an adjudication decision is to be implemented within 14 days, or if it is taken to an enforcement before the TCC fairly promptly thereafter, once you get your enforcement order. But it can be overturned by the courts or an arbitrator, depending on your dispute resolution clause, by considering the substance of the claim. And I've set out there on the slide the well-known quote from Macob and Morrison that explains the position. Turning then briefly to the scheme, if you have a construction contract and your contract does not comply with Section 108 of the Act, the scheme will replace what your contract says in relation to adjudication. Even if the non-compliance in your contract is partial, the scheme will be incorporated, and the phrase is lock, stock and barrel, which comes from Wild set out on the slide. So you need to be really careful when you're drafting contracts here to ensure that you comply with the Act in all respects. The scheme provides for a number of defined steps. It starts with a dispute. For those non-contentious lawyers listening in, there's often a drafting amendment here to allow more than one dispute to be referred. Following your dispute, there should be a notice of adjudication, which briefly sets out the nature of the dispute and the redress sought. Importantly, this is the document that sets out what the adjudicator has jurisdiction to determine, and we'll come back to that shortly. The referring party then needs to request an adjudicator or a nominating body to act. Usually there is a named adjudicator or a nominating body in your contract, and that must be followed. Then your adjudicator is nominated, and not later than 7 days from your notice, you need to provide a referral notice, which sets out in substance the nature of your dispute, accompanied by the contractual extracts and the documents you rely on. So once you have your adjudicator, they are required to act impartially. That's provided for by the Act and as a fallback by the scheme. And they are permitted to take the initiative in ascertaining the facts and the law, again, set out in the Act, and the fallback is in the scheme. In terms of challenging an adjudicator's decision, because of the aims of the legislation that underlie this form of dispute resolution and the temporary nature of adjudication, there are very limited grounds on which you can resist payment of an adjudicator's decision, other than commencing proceedings to deal with the substance. And I've set out there on the slide some well-known quotes that explain the position. In broad terms, the grounds on which you might be able to resist enforcement are firstly, natural justice. I referred earlier to the Act that requires an adjudicator to act impartially. But that question has to be considered in the context of the nature of adjudication, and no one has much time to make their submissions. It's quite a quick process, quite rough and ready. So when you're looking at whether a party's had an opportunity to fairly present its case, it's got to be in that context. The kinds of things that might make out grounds for breach of natural justice are bias, actual or apparent. So, for example, unilateral contact by the adjudicator with one of the parties, or improper conduct of a hearing. Another ground you might be able to make out is a jurisdictional ground. And this is a challenge based on the fact that the adjudicator decided something he was not entitled to decide. So it's about answering the wrong question rather than answering the right question, but in your submissions in the wrong way. So what was the adjudicator entitled to decide? You need to go back and look at what the contract says, see whether you've got a construction contract, whether adjudication would otherwise be excluded by the Act, whether the adjudicator went outside the terms of their reference, or perhaps whether it was properly referred. These are the kinds of things you're looking for. And finally, I put on the slide insolvency. So here you're looking to demonstrate that there is a real risk that the receiving party would be unable to repay if you have to pay money over, and that's because of the temporary nature of an adjudication and an adjudicator's decision. But it's just pausing to note there, you've got to demonstrate that the financial position of the other party is worse than when you first entered into the contract, and that was not due to the paying party's failure to pay sums awarded by the adjudicator. So financial position has got worse and it's not your fault. Swiftly then moving through adjudication and having a quick look at what some of the standard forms say. On this slide, I have summarised the NEC 4 contract and the options clauses that you can select in relation to adjudication. You need to use the W2 option if your contract is subject to the Act. You can use W1 if not. The key difference between them is whether a referral to a senior representative is a mandatory first step. The Act provides a right to refer to adjudication at any time. And so where the Act applies, the first referral to senior representatives is not a mandatory step, so as not to contravene that right to refer at any time. 2 key points to note for today. I mentioned that adjudication decisions generally have a temporary finality. However, under NEC, the adjudicator's decision becomes final and binding if the parties do not give their notice of intention to refer to a tribunal within the time stated in the contract. So beware, get your notice in if you want to dispute your decision. And the second point to note is, unless the parties agree otherwise under the NEC form, parties must refer disputes to adjudication before they can take to a tribunal. So that may well be a ground for stay of later proceedings. Moving swiftly on then, given the time we have today, to the next topic, dispute adjudication or avoidance boards. This is usually a person or a panel of individuals. When you have a panel, it's normally 3, who provide non-binding or temporarily binding advice to the parties, usually during the course of the project. It's a new option provided in the NEC 4 contract, and it's the primary means of dispute resolution in the FIDIC contracts. It's a step before you can arbitrate your disputes. It's very common in international disputes, a bit like an international form of adjudication. Why do it? What are the benefits? Well, it can be quite speedy. It can be quite a cost-effective way of resolving a dispute. If you've got a DAB that's set up early in your project, they may acquire ongoing knowledge of the project. Often you have a DAB, a standing DAB, who might visit the site periodically, even if there isn't a particular dispute that they need to determine. And so they have quite a good understanding of progress, technically how the works ought to progress, technically how bits of the project are supposed to be constructed. And the parties can sometimes find that it avoids a more costly or a slower arbitration or litigation procedure down the line. So let's have a quick look at what some of the standard forms say about DABs. This is the NEC 4 option W3, which is very much aimed at the international market. Under the W3 options clause, the dispute avoidance board assists the parties to resolve potential disputes before they become disputes, or that's the aim. W3 draws a distinction between what it calls potential disputes and disputes, and a DAB can only deal with the former. I'm not sure it's quite clear yet what this means. It might be that potential disputes include disputes, or that there can't be a dispute under W33 unless and until a party is dissatisfied with the decision of a DAB. I'm going to have to wait to see, but if you are a non-contentious drafter, you might want to make this clear if you're going to select something like a W3 options clause. Under NEC 4, the Dispute Avoidance Board visits the site at regular intervals, and the purpose of that visit is to enable them to inspect the progress of the works and become aware of any potential disputes that might arise. Normally, the decision of the DAB is temporarily binding, much like adjudication. But again, just to flag, note here that you need to give notice if you're dissatisfied with the decision of the DAB. You can refer any decision or failure to make a decision to a tribunal for final determination, if done so within 28 days of the DAB's recommendation, and that's W332, which is on the slide. Let's have a quick look at another standard form. I've set out here the FIDIC form. In the 99 suite of FIDIC contracts, they generally refer to a dispute adjudication board. In the 27 suite, they refer to a dispute avoidance board. The distinction being that under the 2017 suite, it's anticipated you would appoint your DAB earlier. You'd have a standing DAB throughout the course of the works. Under the FIDIC forms, the procedure for resolving disputes is multi-tiered. You normally start with an engineer and an engineer's decision. The contractor would notify the engineer of its claims, send details to the engineer, following which the engineer would make a decision. If that decision is disputed, the party can refer the dispute to the DAB, and the standard forms usually require a decision of the DAB within 84 days, but it's nearly always amended in my experience. Following the DAB's decision, if you're not happy with it, within 28 days, if we're under the standard wording, the party needs to give a notice of their dissatisfaction, which then makes the DAB's decision binding, but not final. And if you don't give that notice, your decision will become final and binding, so watch out. The FIDIC form also then provides for an amicable settlement step. I query the extent to which that's enforceable, particularly if you start tinkering with the wording. But the next step that the FIDIC forms envisage is an attempt to resolve the dispute amicably. And then arbitration is the final step in that process. Generally, you can't skip your DAB and go straight to arbitration. I've set out on the slide there the case of Peterborough and Enterprise Managed Services. That said, it's fairly common for the parties to enter into side agreements, agreeing to dispense with the DAB process, particularly if it's later into a dispute where there have been a number of DABs and the parties really want to wrap everything up in a final arbitration. The 99 Red Book and the 27 Teen Suite provides for a standing DAB, much like the NEC option W3, and this provides for a DAB to be appointed shortly after the commencement of the works. I've set out on the slide some of the key terms under the FIDIC form. The points to note really are, firstly, you need a dispute, normally a letter stating that a party disputes an engineer's decision is likely to be enough. You then need to make sure you really carefully follow the contract with respect to who the adjudicators are or should be nominated by. The dispute then needs to arise out of or be in connection with the contract or the works. It's usually fairly easy to satisfy that, but some claims can fall foul of it. Fairly quick, as I mentioned, the standard form provides for a decision within 84 days, and it's temporarily binding. But just remember to give your notice of dissatisfaction if you don't like the decision, otherwise you're stuck with it. So that's all I was going to say today on DABs. Moving then to the next topic, emergency arbitration. This is of a slightly different order to adjudication and DABs, but I think it's notable and a notable tool in your armoury. And it's an ability to apply for emergency measures in arbitration proceedings, typically interim or conservatory measures that can't await the constitution of an arbitral tribunal. And I think it's worth mentioning because it might be that is all a party really needs, is just some form of interim or conservatory measure, and it can be a really useful tool in unlocking a dispute between the parties. I've set out on the slide how the ICC rules 2012 deal with emergency arbitration. Just some points to note. You need to file a request for arbitration on the merits within 10 days of your application. So you will have to go a little bit into your substantive dispute. I think currently there's about a $40,000 application fee. I assume that's to deter some of the more frivolous claims. So you need to be quite serious about the need for this. You need to convince the ICC of the urgency of your application. You need to demonstrate that the relief you're seeking can't wait the constitution of an arbitral tribunal. And if you convince them, you normally get an arbitrator within 2 to 3 days of your application, so really quick. Just to watch out here, whilst the rules provide for this emergency arbitration procedure, there is a recognition that there could be an implied form of opt-out from it by some form of agreed pre-arbitral procedure. So perhaps a DAB under a FIDIC form might be taken as an implied opt-out. But if you fall within the arbitration rules, the parties have a contractual obligation to comply with the decision of the emergency arbitrator. So failure to comply typically lies in an action for damages. Just to be aware, the tribunal has the power to later modify, terminate, or annul an order made by your emergency arbitrator. But it doesn't appear to me that you need a full arbitration at the end of this procedure. So as I said at the start, could be a very useful tool, might be all you need. So that's emergency arbitration. Moving then to the last topic, mediation. I think most on this talk will know what mediation is. It's a means of dispute resolution where the parties' negotiations are facilitated by a neutral third party. Construction contracts commonly provide for mediation, and you see different forms of compulsion in the different forms. I've given on the slide the example of the JCT 2011 design and build contract and clause 9.1. If the Act applies in the UK, the party's construction contract must be subject to the right to adjudicate at any time. So it provides for a non-mandatory mediation first, which you can see reflected there in the JCT drafting, and it makes the mediation provisions subject to Article 7, which is the right to refer to adjudication. I set out on the slide there some common referring bodies to have regard to. And I just want to end with a couple of thoughts on mediation and some interesting issues which commonly arise, and most commonly is the degree of compulsion that a mediation clause requires. I've referred there to the Channel Tunnel and Balfour Beatty litigation, where the relevant clause of the contract provided for the initial reference of disputes to a panel of experts and thereafter provided for final settlement by arbitration. And in that case, the House of Lords held that the court has inherent power to stay proceedings brought before it in breach of such an agreement. So they really can bite. Oath and operations is a useful case in this context, the decision of Mrs. Justice O. Farrell, who set out some of the key principles to be applied when considering the degree of compulsion set out in your mediation clause. And she said that the agreement must create an enforceable obligation requiring ADR. Your obligation needs to be clearly expressed as a condition precedent. It doesn't have to be a formal ADR procedure, but it needs to be a sufficiently clear and certain procedure by reference to objective criteria so that the court could step in and operate the provision if there was a breakdown between the parties. I've just ended there with children's art partnerships, which provides a slight gloss on the criteria given by Mrs. Justice O. Farrell, just to flag that it's subject to an appeal currently. In that case, one aspect of the summary was doubted, and it was suggested that you don't necessarily need a condition precedent to engage the court's powers. A mandatory ADR provision may be enough. And I think a bit of a warning to parties, the available powers to the court are not just a stay to allow the parties to engage in ADR. There's also CPR 11.1b, which provides a discretion to the court, which includes much wider powers, including setting aside the claim form, which was material in the children's art case, because the limitation period to commence the proceedings had expired just over a week after issue of the claim form. And the defendant said that if the claimant had complied with the contract and had first engaged in ADR, it would have had a limitation defence, which it was now deprived of. I mean, on the facts, this didn't bite because the court found that the relevant clause was not sufficiently certain. But you can see there, if you've got a clause that's sufficiently certain for the court to enforce, you might really acquire quite a strong tactical step, which has the propensity to knock out a claim and time bar it forevermore. The final point I wanted to end with is a bit of a warning about mediation generally. You don't necessarily need a mediation clause in your contract for there to be consequences for a party who unreasonably fails to engage in ADR. Absent a mediation clause, unreasonable refusal to mediate might result in cost consequences, the refusal of an application for security for costs, or enhanced interest. And I've set up there a few cases to have a look at. So I think we're within time, and I conclude my whistle-stop tour of an introduction to dispute resolution in the construction law context. And thank you very much all for listening.